Officer, what time was the vehicle towed to impound? That was the question. Not the kind that arrives with thunder, not the kind lawyers rehearse for television. It came out flat, almost polite. Defense counsel didn't raise his voice. He didn't pace. He didn't point. He just stood there with one sheet of paper in his hand and asked for the tow time. The officer had been owning that courtroom for the better part of an hour. Chin up, back straight, answers clipped and ready. He had already told the jury he stopped the defendant at 11:42 p.m., searched the car during the traffic stop, found narcotics in the center console, secured the scene, and then had the vehicle towed. He said it the way some men say their own name. So when the question came, he barely glanced at the paper. 11:38 p.m., he said. Defense counsel did not sit down. He did not smile. He did not look at the jury. He looked at me. Then he looked back at the officer and said, "So the car was already gone 4 minutes before you searched it?" The room changed all at once, not gradually, not politely. The prosecutor was on his feet before the last word landed. "Objection mischaracterizes the testimony." The officer leaned forward. "No, that's not what I said." Defense counsel stepped toward the witness box. "You said the tow was 11:38. That's the tow record," the officer snapped. "And you testified the search occurred at 11:42. That's when I located the narcotics. In a car that had already been impounded? Clerical error." He said it too fast. "I have spent enough years on the bench to know the sound a lie makes when it realizes it has company." The prosecutor asked to approach. I said no. He asked for a sidebar. I said no again. He tried to cut the moment in half before the jury could feel its weight. That is what people do when the floor opens under them. They don't fix the truth. They try to muffle the sound it makes. I turned to the officer. "Answer the question directly." He swallowed and adjusted his collar. "The time on the tow sheet is wrong." Defense counsel lifted the page in his hand. "Signed by your partner?" "Yes." "Entered by dispatch?" "Yes." "Time stamped automatically?" "I don't know." "You don't know?" The officer's jaw tightened. "There are errors sometimes." Defense counsel took one step back, just enough to let the silence stand between them. That silence did more damage than shouting ever could. Ladies and gentlemen watching this now, if you want to understand how a courtroom actually breaks open, it is not with a confession. It is with a detail so small nobody thinks to protect it. A minute, a signature, a receipt, a timestamp. That day it was 4 minutes, and 4 minutes was enough to put a badge on trial. The prosecutor redirected immediately. He had to. He started throwing ropes to a drowning witness. "Officer, is it common for paperwork to contain errors in the field?" "Yes." "Did you in fact recover narcotics from the defendant's vehicle?" "Yes." "Was the defendant present?" "Yes." "Did you maintain chain of custody?" "Yes." He was trying to rebuild certainty faster than the jury could lose it. I watched the officer while he answered. He had stopped looking at the jurors. He kept looking at the prosecutor, waiting for the next safe question, like a man crossing a river, on stones that were sinking behind him. Defense counsel rose again. He asked for the impound intake log. The prosecutor objected before the request was complete. "No foundation." Defense counsel already had it. He had the copy in his file. He had been waiting. He held it up, and I could see the prosecutor realize too late that he was no longer fighting a theory. He was fighting paper. I admitted the log. Defense counsel approached the witness. "Officer, the impound intake time reads 11:41 p.m., correct?" "Yes." "And your search, by your testimony, happened at 11:42? "Yes." "So 1 minute after the car reached impound, while you were still roadside?" "No." "No?" "No. I searched it before." "Then your testimony was false?" "No." "Then the tow log is false?" "Yes." "The dispatch sheet is false?" "Yes." "The impound intake is false?" I said there was a clerical issue. "A clerical issue in dispatch, tow and impound all at once?" The prosecutor was up again. "Asked and answered." "Sustained," I said, "but the damage was done, not because of the question, because of what the officer had been forced to protect. When a witness starts choosing which official records exist and which do not, the jury does not hear confidence. It hears desperation dressed in uniform. The defense lawyer could feel it. He pushed. "Officer, did you activate body camera? It malfunctioned. Dash camera? Not working. Any photographs of the console before recovery? No. Any civilian witness? No. So the only thing placing those drugs in that car at that time is you." The prosecutor objected again, louder now, like volume could reverse sequence. I overruled him. The officer said nothing for a beat too long, then, "Yes." There are moments in court where the truth is not yet proven, but the lie has already started running. I saw it in the prosecutor's hands. He kept rearranging his pen and yellow pad, not reading them, just touching things. He asked for a brief recess. Defense objected. I took the recess anyway, but not for the reason either side thought. I told counsel to remain available. Then I had the clerk bring me the impound exhibit, the dispatch sheet, and the property voucher. The property voucher was where the second crack appeared. Evidence submission time, 11:36 p.m., 2 minutes before the toll request, 6 minutes before the alleged roadside search. I read it once, then again. Then I checked the notation under the officer's signature, recovered from vehicle search. I looked up at my clerk. She had seen it too. She didn't speak. She just placed the file squarely in front of me and waited. The prosecutor came toward the bench, already talking. Judge, if the court is concerned, we can recall the record's custodian, straighten out the times. Sit down, I said. He stopped. I do not raise my voice often. I have never needed to. In a courtroom, quiet authority travels farther than anger. I asked the clerk for the officer's recent testimony index from our criminal calendar. Every judge has instincts. Mine was telling me this was not a loose thread. It was a seam. The clerk returned with a printout. The officer had testified in 34 drug possession cases in 18 months. 34. Same precinct. Same recovery language in most of them. Observed furtive movement. Conducted probable cause search. Recovered suspected narcotics from center console, or glove box, or underseat compartment. The wording shifted only enough to look new. The rhythm stayed the same. I have seen productive officers. I have seen specialized units. I have seen busy dockets and neighborhoods that keep a courtroom full. But 34 appearances from one officer, each with near-perfect recovery narratives and near-perfect memory, is not diligence. It is a pattern asking to be read. When we resumed, the prosecutor tried to narrow the issue. That told me he understood exactly how large it was. Judge, the question before the jury is possession, not paperwork. Defense counsel said, the paperwork is the possession. The officer turned to look at him so sharply, the bailiff shifted where he stood. I leaned forward. No, I said to the prosecutor. The question before the jury is whether this evidence exists inside a legal timeline. If it does not, then your case does not shrink, it disappears. You could hear someone in the gallery move in their seat. The prosecutor asked to recall the officer to clarify administrative discrepancies. That phrase stayed with me, administrative discrepancies, as though time itself had committed a filing error. I allowed the recall. The prosecutor stood close to the witness now, close enough to coach by posture, if not by word. Officer, can you explain how multiple timestamps might appear inconsistent? Yes, sometimes paperwork is generated in advance. In advance of what? In advance of transport. In advance of recovery. A pause. In some circumstances. Defense counsel stood before I could speak. In advance of discovering the narcotics? The prosecutor objected. I let the witness answer. The officer said, no. But he had already opened the door, and the draft was moving through the whole room. Defense walked through it. Officer, did you sign the property voucher before the narcotics were allegedly found? No. Then how did the voucher log the evidence at 11:36? I can't answer that. Did someone else sign for you? No. Did someone back enter the time? I don't know. Did you fabricate the recovery? No. And yet the evidence was logged before your search, the tow occurred before your search, and the vehicle reached impound before your search. The prosecutor objected to every clause. He was no longer protecting testimony. He was trying to break momentum, to cut every sentence into pieces small enough that no one could see the shape of it. I overruled him. The officer gripped the rail of the witness stand. I recovered those drugs, he said. Defense counsel nodded once, as though he had been waiting for that exact insistence. Then he asked for the evidence locker sign-out logs. The prosecutor nearly shouted this time. Relevance. Defense answered without turning. Credibility. I took the logs under review and called a short recess. That recess was not short. I stayed in chambers with the clerk, my court attorney, and the file spread across my desk. I asked for 6 prior case files from that officer's testimony history, not random. I chose the ones closest in date and the ones with the same recovery language. One by one they arrived. One by one we opened them. One had evidence bag issuance at 9:14 p.m. and recovery narrative beginning at 9:27 p.m. Possible on its face until you read the dispatch arrival at 9:31. Another had narcotics photographed into evidence before the arrest was marked complete. Another had a tow request entered before consent to search was supposedly obtained. Another had the body camera marked inoperative with no maintenance ticket attached. Another had inventory forms completed with empty fields where case numbers should have been, then later filled in with different ink. By the fourth file, nobody in chambers was speaking unless necessary. By the sixth, I was no longer asking whether the witness had lied that day. I was asking how long the court had been asked to call fiction by the name of evidence. If you are still with me, stay with me now, because this is where most people imagine the system corrects itself quickly. It does not. It resists correction. It resists it with procedure, with delay, with embarrassment, with every institutional instinct that says contain the damage and move on. Truth in a courtroom does not arrive to applause. It arrives to opposition. When we went back on the record, the prosecutor had changed tone completely. Gone was the confidence. In its place came caution and retreat. The people request an adjournment. Defense was on his feet before he finished. No, my client has been in custody for 4 months. The people need time to review collateral record issues. Defense laughed once. Not because anything was funny, because he had finally heard the state admit there was something to review. I asked the prosecutor, "Are you representing to this court that the integrity of the evidence is now in question?" He looked at the file. He looked at the officer. He looked anywhere but at me. "We believe there may be documentation irregularities." That phrase joined the first one. Administrative discrepancies. Documentation irregularities. When plain facts become fatal, language starts dressing the body. I denied the adjournment. The prosecutor asked to confer privately with the witness. Denied. He asked to excuse the jury for the afternoon. Granted. Once the jurors were out, the room lost its performance voice. Courtrooms sound different when no one is pretending for 12 strangers. I ordered the property clerk and evidence custodian to appear immediately with the original locker sign-out sheets. The officer shifted in the witness chair. "Judge, with respect, this is unnecessary." I looked at him. That was enough to end the sentence. The custodian arrived carrying a binder thick with chain logs, initials, bag numbers, and issue sheets. We placed it on the witness stand rail and turned to the officer's entries. 3 empty evidence bags, signed out on dates tied to no case number. 2 more bags signed out under his badge number, with blank recovery fields. 1 bag voided without supervisor notation. Defense counsel did not rush. Good lawyers do not rush when the ground is already caving. "Officer, why did you sign out empty narcotics bags without a case assignment?" "I don't recall." 5 times? "I handle a lot of evidence." "We know." The answer came out harder than he intended, and the courtroom caught it. Sometimes arrogance returns at exactly the wrong moment, and that moment is usually the truth. Defense turned another page. Bag number 44721, signed out by you. No case number, no arrest number, no disposition. Where did it go? "I don't know." Bag number 44725, same thing. "Where did it go?" "I don't know." Bag number 44731, same thing. "Where did it go?" The officer looked to the prosecutor. I stopped him there. "The witness will answer the question without assistance." He licked his lip once. "I don't know." Defense nodded again. "You don't know where empty narcotics evidence bags went after you signed them out?" "No." "Do you understand why that matters?" The prosecutor objected. Sustained. But the question had done its work, not because it was answered, because it did not need to be. I called the clerk to the bench and directed her to contact the administrative judge, quietly. I also directed that copies of the 6 prior files be secured, and that no record connected to those matters be released or altered without court order. I chose my words carefully because by then I was no longer dealing only with a trial. I was dealing with a possible pattern inside a precinct that had already passed through my courtroom under oath. The prosecutor saw the clerk leave and understood this had moved beyond salvage. He made one last attempt. "Judge, the people moved to strike the witness's time testimony and proceed on the physical evidence alone." I said, "You cannot sever poison from the cup after it has been poured." He had no answer to that. Then the officer spoke out of turn. "This is about a typo." Defense snapped back. "Then swear to that." I already did. Swear every timestamp in your paperwork is wrong, except the one that convicts my client. The officer half rose from the stand. The bailiff stepped in. The prosecutor put a hand out without touching him. For 1 second, the badge, the suit, the rail, the bench, the whole machine of order looked thin. That is what lies do in court when they stop working. They don't just threaten a verdict, they threaten the arrangement everybody came in expecting. I instructed the witness to sit down. Then I did something Judges do rarely, and never lightly. I began asking my own questions. Officer, when exactly did you first place your hands inside that vehicle? Approximately 11:42. Was the vehicle in your custody at that time? Yes. Where? At the stop. Then why does impound receive it at 11:41? I can't explain that. Why does property log the narcotics at 11:36? I can't explain that. Why do you have multiple empty evidence bags signed out without case numbers? I can't explain that. Can you explain anything in your own paperwork today? The officer said nothing. I let the silence stand. Then I asked one more. Should this court rely on your testimony to take a citizen's liberty? The prosecutor objected instantly. Too late. The officer looked at me, and for the first time that day, he had no prepared posture, no memorized cadence, no prosecutor's ladder under his feet. He said, yes, not because the facts supported him, because surrender had never been part of his job. That answer finished it. I found the witness not credible as a matter of law on the evidentiary issues before me. I struck the narcotics evidence. I granted the defense motion for acquittal. The defendant did not shout. Most people think freedom sounds loud. Often it sounds like somebody forgetting how to breathe. The prosecutor asked to be heard. I said, you have been heard. Then I said the part that mattered most, and I said it into the open record, where nobody could sand it down later. This court is referring this matter for immediate criminal and administrative review based on apparent evidence fabrication, false testimony, chain of custody irregularities, and a demonstrable pattern extending beyond this case. The referral shall identify the officer by name and the precinct of assignment. You could feel the room stiffen. The officer said, Judge, I brought the gavel down once. Not hard. Just once. Do not interrupt this court again. I continued reading. The court further directs preservation of related evidence records, dispatch logs, impound files, evidence locker signouts, body camera maintenance records, and prior case materials identified during recess review. The prosecutor stood motionless, like a man who had discovered halfway through the fire that the exits were locked from the inside. Defense counsel put a hand on his client's shoulder. The client never took his eyes off the witness stand. And because some truths must be spoken where the institution can hear itself, I added this. One impossible timestamp may be dismissed as error. A series of impossible timestamps is not error, it is method. I ended the session, but the case did not end there. Within days, the officer was suspended. That was the administrative word, suspended. It always sounds temporary, almost technical, as though a man has merely been moved aside for repairs. Then came the arrest. More records were pulled, more property logs examined, more cases compared. 11 prior convictions were reopened, not reviewed casually, reopened. Lives that had already been boxed, labeled, and shelved were brought back under light because one defense lawyer refused to step over 4 impossible minutes. You want to know what stays with a judge after a case like that? Not the headlines. Not the outrage from commentators who discover the justice system every few months and speak about it like weather. What stays with me is the ordinary machinery of it, the forms, the initials, the neat times printed in black ink, the way paperwork can look so official while carrying a lie from one desk to another. A falsehood does not need drama to survive. It needs routine. It needs people willing to say, this looks close enough, and move it along. I have seen honest officers testify with care and restraint. I have seen prosecutors dismiss cases when a witness falters by a fraction of what happened here. I have seen defense lawyers lose on cleaner records than this one because they lacked the one page, the one question, the one moment. So I am not careless with condemnation. I do not confuse error with corruption. I do not mistake imperfection for fraud. But I know the difference when time itself refuses to cooperate with a story. The officer in that case had counted on several things. He counted on the jury trusting the uniform. He counted on the prosecutor needing the case. He counted on the defense being underfunded, overworked, and half a step late. He counted on the court treating timestamps like clerical dust. Most of all, he counted on repetition. Once a false method survives enough times, the person using it starts to believe it has become reality. That is one of the oldest dangers in a courtroom. Not the first lie, the practice lie, the one that has crossed the room so many times it forgets it can still be stopped. And let me tell you something directly. If you have ever sat in a courtroom and assumed the robe knows everything the minute it happens, that is not how this works. Judges are not handed truth. We are handed versions. We see what the parties bring, what the records show, what witnesses dare to say under oath. The system is only as honest as the pressure applied to it. On that day, pressure came from one narrow question, and the refusal to let anyone hurry past the answer. That is why details matter. That is why defense matters. That is why records matter. And that is why people who tamper with evidence are not merely cheating a defendant. They are poisoning every honest case that comes after. Every lawful arrest, every truthful officer, every victim who needs a jury to believe the state when the state deserves to be believed. Fabrication does not just frame the innocent. It weakens the guilty cases too, because eventually the public stops knowing where truth ends and convenience begins. Some of you watching know exactly what I mean. You have seen forms that make no sense, reports that read like templates, authority used as a shortcut. Some of you have also seen the opposite. Careful police work, exact records, testimony that does not need decoration. The difference between those two worlds is often smaller than the public thinks. Sometimes it is one person deciding whether the paper must match the truth, or whether the truth must be bent to match the paper. That officer made his choice long before he stepped into my courtroom. By the time he took the stand, all that remained was whether the record would finally stop protecting him. It did. Not instantly, not cleanly, not without resistance, but it did. And I will tell you one more thing. The defendant in that case was not rescued by luck. He was rescued by scrutiny. There is a difference. Luck is blind. Scrutiny is a duty. Courts do not exist to reward whoever sounds most certain. Courts exist to test certainty until only what is real survives. That day, certainty died first. Then the story died. Then the case. Then, piece by piece, the protection around the man who had been telling it. I have presided over more cases than I can count. I have heard every kind of excuse and watched every kind of performance. I have seen witnesses collapse, lawyers overplay, defendants sabotage themselves, and truth arrive dressed so poorly, nobody wanted to let it in. But every so often, the entire architecture of a lie rests on something absurdly small. A receipt, a log, a minute hand, a car that wasn't there yet, or rather wasn't there anymore. That is what happened. An officer swore he found drugs in a vehicle at 11:42 p.m. The tow record put the car in motion at 11:38. The impound log received it at 11:41. The property voucher booked the narcotics at 11:36. He called it clerical error. The records called it something else. I called it what it was. And when I read that referral into the record, I was not making a speech. I was doing the simplest job a judge has, saying out loud what the evidence leaves no room to deny. One impossible timestamp. That's all it takes for an entire system of lies to collapse.